All right, so let's jump into it today. We're going to be looking at tenant rights in California.
Oh.
Specifically when there's no written lease. I know you're an attorney at the Martinez Law Center, and you specialize in tenant eviction cases in Southern California, so this is going to be right up your alley.
Absolutely.
We've got a whole bunch of sources here that are all about California law, which is perfect for your practice.
Perfect.
In Orange County, Riverside, San Diego, and Los Angeles. And trust me, even with your legal expertise, I think there might be a few things in here that surprise you.
I'm excited to find out.
So let's just jump right in and tackle one of the biggest misconceptions right off the bat.
Okay.
A lot of people think that if there's no written lease, tenants have no rights.
Right.
What's the reality in California?
So that's a huge myth that we need to debunk right away.
Okay.
California is really strong when it comes to protecting tenants, even without a formal contract.
Okay.
We've seen a real shift in recent years, especially with the Tenant Protection Act of 2019.
Oh, yeah. AB 1482, that one's been a big one.
It really has. One of the biggest wins for tenants is the just cause eviction requirement.
Right.
This means a landlord can't just evict someone because they feel like it.
Right.
There needs to be a valid reason.
So it's not like a free-for-all for tenants, but it does give them some really crucial safeguards.
Exactly. Now, just cause can be at fault, meaning the tenant did something like not paying rent or violating terms that were agreed upon even if they weren't written down.
Gotcha.
But it can also be no fault.
No fault. That sounds kind of tricky for tenants. What are some examples of that?
So think about situations where the landlord wants to move into the property themselves.
Okay.
Or maybe they want to take it off the rental market completely.
Uh-huh.
These are considered no-fault evictions, even if the tenant hasn't done anything wrong.
So even a model tenant could get evicted.
They could. It can be tough, but AB 1482 does have some protections in place.
Okay.
For example, tenants evicted for no-fault reasons in covered properties might be entitled to relocation assistance. Oh, interesting.
That's something that you could really use to help your clients at the Martinez Law Center.
That's great to know, but even with a just cause reason, I'm guessing landlords can't just kick people out immediately.
Right.
There must be some kind of notice period.
You're absolutely right. Even with a valid reason, landlords have to follow specific notice periods.
Okay.
And how long that period is depends on how long the tenant has been living there.
So let's get into the specifics. What are the different time frames we're talking about?
Sure. So for tenants who've lived in a unit for less than a year, it's a 30-day written notice.
Okay.
But if they've been there for a year or more, the notice period goes up to 60 days.
So at least they have a little bit of time to prepare, even in a worst-case scenario.
Exactly.
What about rent increases, though? Can landlords just raise the rent whenever they want?
Not in California. We've got some pretty strict rules about rent increases, too.
All right, break it down for us. What's the deal with rent increase notices?
So for increases of 10% or less, landlords need to provide a 30-day written notice.
However, if they want to raise the rent by more than 10%, then they're required to give a 90-day notice.
Oh, wow, that's a big difference.
It is.
So if it's going to be a big increase, tenants have more time to adjust.
It's all about giving tenants a fair chance to plan.
Right. And in your line of work, I'm sure those extra days can make all the difference.
Absolutely. We've seen how crucial those notice periods can be for tenants facing those difficult situations.
For sure. Now, speaking of protections, let's move on to something that I know you're really passionate about.
Okay.
And that is habitability standards. So what rights do tenants have when it comes to the condition of their rental unit?
Yeah.
Even if they don't have a formal lease?
This is where things get really interesting, even without a lease. California law requires landlords to maintain a safe and livable environment for their tenants.
Okay.
This is known as the implied warranty of habitability.
Implied warranty of habitability. That sounds pretty serious. What exactly does that cover?
It covers a lot, actually. Think of it as the basic necessities for a functional and safe living space. We're talking about things like working plumbing and electrical systems, adequate heating and hot water,
Right.
and effective waterproofing to prevent leaks and mold.
So no leaky roofs or faulty wiring.
Exactly. And it's not just about functionality, it's also about sanitation and safety.
Okay.
Landlords are obligated to address issues like pest infestations,
Right.
inadequate garbage disposal,
Uh-huh.
and any other conditions that could pose a health hazard to tenants.
That makes a lot of sense. Everybody deserves to live in a safe and healthy environment.
Absolutely.
But what happens when a landlord doesn't meet these habitability standards?
Right.
What recourse do tenants have, especially if they don't have a written lease?
Well, California gives tenants a few different options.
Okay.
And it's important for you as an attorney to know how to use these to help your clients.
For sure.
One option is the repair and deduct remedy.
Okay.
This allows tenants to make necessary repairs themselves and then deduct the costs from their rent.
So that's a pretty practical solution for smaller issues.
It can be, but there are limitations.
Okay.
Tenants can only use this remedy once every 12 months.
Okay.
And the cost of the repairs can't be more than 1 month's rent.
Gotcha.
Plus, they need to provide proper notice to the landlord and give them a reasonable opportunity to fix the problem first.
So it's not a free pass to just go and do DIY on every little thing.
Right.
There's a process they have to follow.
Exactly. And documentation is crucial here.
Okay.
Tenants need to keep detailed records of all communication with the landlord,
Uh-huh.
including repair requests,
Okay.
photos of the issue,
Right.
and receipts for any materials or labor costs.
Yeah, I can imagine that documentation would be really important in court.
It can make or break a case. Another option for tenants is reporting the issue to local code enforcement agencies.
Okay.
These agencies can investigate the complaint,
Right.
and they can potentially force the landlord to make repairs if they find violations.
So that adds another layer of accountability.
It does.
So tenants aren't just left on their own to deal with these issues.
Exactly. And this is especially important for tenants without written leases who might feel like they have fewer options.
Right. Okay, so we've covered just cause evictions, notice periods, and habitability standards.
Right.
Let's move on to another area where tenants often have questions, and that's landlord entry.
Okay.
So what are the rules in California, especially when there's no written lease to spell things out?
So this is where the tenant's right to quiet enjoyment comes in.
Okay.
Even without a lease, tenants have the right to privacy and peaceful possession of their rental unit.
So landlords can't just barge in whenever they please.
Definitely not.
Yeah.
California law requires landlords to provide tenants with proper notice before entering the unit for non-emergency reasons.
So what kind of notice are we talking about?
Generally, landlords need to provide a 24-hour written notice before entering for things like routine repairs inspections or to show the unit to prospective tenants or buyers.
Right.
And they typically can't enter outside of normal business hours unless the tenant agrees.
So no surprise inspections or late-night visits.
Right. And it's important to note that this right to notice applies even if the reason for entry seems really minor.
Right.
It's about respecting the tenant's privacy and space.
But what about emergencies? I'm guessing there are exceptions to the 24-hour rule.
Of course, in emergency situations like a fire, a burst pipe, or a gas leak, landlords can enter immediately to take care of the problem.
Right. It's all about safety in those situations.
Yeah, exactly. It's about ensuring the safety of the tenants and the property.
Makes sense. Safety comes first. But even in those situations, it's probably good practice for the landlord to follow up with the tenants.
Yeah.
And just explain why they had to enter.
Absolutely.
Yeah.
Transparency and communication are key to maintaining a good landlord-tenant relationship.
Right, even in challenging situations. Okay, so we've talked a lot about tenant protections.
We have.
But what about something like security deposits? How does California law protect tenants in that area?
Right.
Particularly when there's no written lease.
So security deposits are another area where California law is really specific.
Okay.
And these protections apply whether there's a lease or not.
So what are the key things that tenants need to know?
Well, first and foremost, there are limits on how much a landlord can charge for a security deposit.
Okay.
For unfurnished units, the maximum is 2 months' rent.
Okay.
And for furnished units, it's 3 months' rent.
So landlords can't just demand some crazy amount up front.
That's right. And when the tenant moves out, the landlord has 21 days to return the security deposit.
Okay.
Minus any lawful deductions.
Lawful deductions. What falls into that category?
Deductions can be made for unpaid rent,
Okay.
damage to the property beyond normal wear and tear, and cleaning costs if the unit is left super dirty.
It sounds like there's some room for interpretation there. How can tenants protect themselves from unfair deductions?
Documentation is key.
Okay.
Before moving in, tenants should really document the condition of the unit.
Right.
Take photos and videos to capture any existing damage. And they should also keep records of all rent payments and communication with the landlord about any repairs or maintenance issues.
So it's all about creating a clear record to back up their claims.
Exactly. And if a landlord does make deductions from the security deposit, they're required to provide the tenant with an itemized statement explaining those deductions.
So that level of transparency is important for both sides.
It is. It helps prevent disputes and make sure that everyone's on the same page.
Right. So we've covered a lot here. Evictions, habitability, landlord, entry, security deposits.
Yeah.
It's clear that California law offers some serious protections for tenants.
It does.
Even those without written leases.
Yeah.
But I know there's another layer to this.
Right.
And that's local ordinances. So how do those come into play?
Yeah.
Especially in the areas where your clients at the Martinez Law Center are located.
You're right. Local ordinances can add an extra layer of protection for tenants.
Okay.
And it's essential for attorneys practicing in California to be aware of these local nuances.
So what are some examples of these local ordinances?
Okay.
And how might they impact your clients?
Well, many cities in Southern California, including Los Angeles, Santa Ana, and San Diego, have rent control ordinances that place limits on how much landlords can increase rent each year.
Okay.
These limits are often stricter than the statewide rent caps, so it's crucial to know the specific rules in each city.
So what might be a legal rent increase in one city could be a violation in another city.
Exactly. And these local ordinances aren't just limited to rent control.
Right.
Some cities have additional protections related to just cause evictions,
Totally.
relocation assistance, and even tenant harassment.
So it sounds like it's a constantly evolving landscape for tenant rights in California.
It is.
How do you stay up to date on all these changes?
Well, it's a lot to keep track of,
Yeah.
but there are some good resources out there to help attorneys and tenants alike.
Okay.
Organizations like the California Apartment Association and Tenants together publish regular updates on changes in state and local laws.
So continuous learning is essential, it seems like. Understanding these rights and protections isn't just about knowing the law.
Yeah.
It's about empowering tenants to advocate for themselves.
Absolutely. And that's where the work you do at the Martinez Law Center is so important.
Yeah.
By providing legal guidance and representation, you're helping tenants navigate these often complex issues
For sure.
and ensure that their rights are protected.
Well said. We've explored a wide range of tenant rights.
We have.
But there's one final crucial point I want to touch on before we wrap up this deep dive.
Okay, I'm all ears.
We've talked about documentation throughout this whole episode.
Yes.
But I want to really underscore its importance.
Yes.
Especially in those cases where there's no written lease.
You are absolutely right to emphasize that documentation is the cornerstone of a strong case for any tenant.
Okay.
Especially those who are relying on verbal agreements.
Right.
Or navigating the complexities of local ordinances.
So can you elaborate on that a little bit? What specific types of documentation should tenants be focusing on?
First and foremost, any communication with the landlord should be saved and organized.
Okay.
Whether it's text messages, emails, even handwritten notes.
Yeah.
If there's ever a dispute, having these records can be crucial to proving the tenant's case.
Okay.
They paint a clear picture of the landlord-tenant relationship.
Right.
And they can really help establish a timeline of events.
So what other types of documentation are important?
Tenants should also keep really detailed records of all rent payments, including the date, the amount, and the method of payment.
Right.
This is especially crucial if they're paying in cash or through any unconventional methods.
So it's not enough to just assume that the landlord is keeping track of everything.
Unfortunately not. It's always best for tenants to have their own records for backup.
Right. And speaking of backups, I imagine photos and videos are really valuable.
Oh, absolutely.
For documenting the condition of the unit.
Tenants should take photos and videos of any existing damage before they move in. And again, when they move out.
Gotcha.
This can help protect them from unfair deductions from their security deposit.
Right.
And it can also serve as evidence in habitability disputes.
So it sounds like documentation is a continuous process.
It is.
Not just something you do at the beginning or the end of a tenancy.
Exactly. It's about being proactive and creating a really comprehensive record that can be used to support their rights as tenants.
And I imagine this is where your legal expertise comes in.
Right.
You can guide your clients at the Martinez Law Center on best practices for documentation.
Absolutely. We can help them understand what to document, how to organize their records, and how to use that information to effectively protect their rights.
Well, we've covered a lot of ground in this deep dive.
It's been a lot.
From just cause evictions and habitability standards to security deposits and documentation.
Yes.
We've explored a huge range of rights and protections that tenants have in California, even without a written lease.
It's impressive how much protection California law offers.
It's clear that California law is on the side of tenants.
It seems that way.
But it's essential to understand the ins and outs of these laws and how to apply them in real-world situations.
Absolutely. Knowledge is power, And the more tenants know about their rights, the better equipped they'll be to secure safe, fair, and stable housing.
Before we wrap up, I want to remind everybody about the valuable resources that are available at martinezlawcenter.com.
Great website.
For anyone who's facing eviction, dealing with habitability issues, or just seeking legal guidance on their tenant rights, the team at the Martinez Law Center is ready to help.
They are a great resource.
And remember, understanding your rights is just the first step. It's about taking action, seeking legal counsel when needed,
right,
and standing up for what you deserve as a tenant.
Absolutely well said.
That's a wrap on this episode of The Deep Dive. Until next time, stay curious and keep diving deep into the world of knowledge.
Great advice.
And remember, your rights as a tenant matter. Don't be afraid to stand up for what you deserve.
Couldn't agree more. It really is. And it's all about providing tenants with a fair chance to plan, in your line of work.
Yeah.
I mean, those extra days can really make a huge difference.
Absolutely. We've seen how crucial those notice periods can be, for tenants who are facing these really difficult situations.
For sure.
Now, let's talk about something that I know is really important to you.
Okay.
And that is habitability standards.
Right.
So, even if a tenant doesn't have that formal lease,
yeah,
what rights do they have when it comes to the condition of their rental unit?
So this is where things get really interesting, even without a lease. California law requires landlords to maintain a safe and livable environment for their tenants.
Okay.
And this is known as the implied warranty of habitability.
Okay. Implied warranty of habitability. That sounds pretty serious. What exactly does that cover?
It covers a lot, actually. Think of it as like the basic necessities for a functional and safe living space. So we're talking about things like working plumbing and electrical systems, adequate heating and hot water,
right,
and effective waterproofing to prevent leaks and mold.
So no leaky roofs or faulty wiring allowed.
Exactly. And it's not just about functionality either. It's also about sanitation and safety.
Okay.
So landlords are obligated to address issues like pest infestations,
right,
inadequate garbage disposal, and any other conditions that could pose a health hazard to the tenants.
That makes a lot of sense. I mean, everyone deserves to live in a safe and healthy environment.
Absolutely.
But what happens when a landlord fails to meet these standards?
Right.
What recourse do tenants have, especially, if they don't even have a written lease to refer to?
Well, California gives tenants several different options.
Okay.
And it's really important for you as an attorney, be aware of these and how to use them effectively for your clients.
Right. Gotcha.
So one option is the repair and deduct remedy.
Okay.
This allows tenants to make necessary repairs themselves and then deduct that cost from their rent.
So that's a pretty practical solution for maybe some smaller issues.
It can be, but there are some limitations.
Okay. What are those?
So tenants can only use this remedy once every 12 months.
Right.
And the cost of those repairs can't exceed 1 month's rent.
Right.
And they also need to provide proper notice to the landlord and give them a reasonable chance to fix the problem first.
So it's not just a free pass for tenants to, go do their own DIY projects and everything.
Exactly.
There's a process that has to be followed.
Right. And documentation is so crucial here.
Okay.
Tenants really need to keep detailed records of all their communication with the landlord. Things like repair requests,
right,
photos of the issue,
okay,
and receipts for any materials or labor costs.
Yeah, I can imagine that kind of documentation could really make or break a case in court.
It really could. Another option is for tenants to report the issue to their local code enforcement agencies.
Okay.
These agencies can then investigate the complaint, and they can potentially force the landlord to make repairs if they find any violations.
So that adds like another layer of accountability for the landlord.
It does.
So the tenants aren't completely on their own in dealing with these situations.
Exactly. And this is especially important for those tenants who don't have written leases.
Right.
Because they might feel like they have fewer options available to them.
Okay, so we've covered just cause evictions. We've talked about notice periods and habitability standards.
We have.
Let's move on to another area where I know tenants often have questions, and that's landlord entry.
Okay.
So what are the rules in California, especially when you don't have that written lease, to clearly spell things out?
Well, this is where the tenant's right to quiet enjoyment comes in.
Okay.
So even without a lease, tenants have the right to privacy and peaceful possession of their rental unit.
So landlords can't just barge in whenever they feel like it?
No, definitely not. California law requires landlords to provide tenants with proper notice before they enter the unit for any non-emergency reasons.
Okay. And what kind of notice are we talking about here?
Generally, landlords need to give a 24-hour written notice before they can enter.
Cool.
For things like routine repairs inspections or to show the unit to prospective tenants or buyers.
Right.
And they typically can't come in outside of normal business hours unless the tenant agrees to that.
So no surprise inspections or, late night visits.
Right. And it's important to remember that this right to notice it applies even if the reason for entry seems really minor.
Okay.
It's about respecting the tenant's privacy in their space.
But what about emergencies? I'm guessing there are some exceptions to that 24-hour rule.
Of course, in emergency situations.
Yeah.
A fire, a burst pipe, or a gas leak, landlords can enter the unit immediately to deal with the problem.
Right. Yeah. It's all about safety in those cases.
Exactly. It's about making sure everyone's safe and protecting the property.
It makes sense.
Yeah.
Safety always comes first. But even in those situations, I imagine it's good practice for landlords to at least follow up with tenants afterwards and explain, hey, this is why I had to come in.
Absolutely. Transparency and communication are so key to maintaining a good landlord-tenant relationship.
Right. Even in those tough situations.
Yeah.
Okay. So we've talked a lot about tenant protections.
We have.
But what about something like security deposits?
Mm-hmm.
How does California law protect tenants in that area, especially when there's no written lease to lay out those terms?
Yeah. Security deposits are another area where California law is really specific.
Okay.
And these protections apply whether there's a lease or not.
So what are the key things that tenants really need to know about this?
Well, first off, there are limits on how much a landlord can charge for a security deposit.
Sure.
So for unfurnished units, the maximum is 2 months rent.
Okay.
And for furnished units, it's 3 months rent.
So landlords can't just demand some outrageous amount of front.
That's right. And then when the tenant moves out, the landlord has 21 days to return the security deposit, minus any lawful deductions.
Lawful deductions. Yeah, what falls under that category?
So deductions can be made for unpaid rent, damage to the property that goes beyond just normal wear and tear, and cleaning costs if the unit is left excessively dirty.
It sounds like there could be some room for interpretation there. So how can tenants protect themselves from any kind of unfair deductions?
It comes back to documentation.
Okay.
Before moving in, tenants should really thoroughly document the condition of the unit.
Right.
So taking photos and videos is a good idea to capture any existing damage. They should also keep records of all their rent payments and all communication with the landlord regarding repairs or maintenance issues.
It's all about creating that clear record to back up their claims.
Exactly. And if a landlord does make deductions from that security deposit, they are required to provide the tenant with an itemized statement that explains all those deductions.
So that kind of transparency, I imagine, is really important for both sides.
It is. It really helps prevent those disputes and make sure that everyone's on the same page.
Okay, so we've covered a lot here. Evictions, habitability, landlord, entry, security deposits.
Yeah.
It's clear that California law offers a lot of protection for tenants.
It does.
Even for those without written leases. But I know there's another layer to all of this.
Right.
And that is local ordinances. So how do those come into play, especially in the areas where your clients at the Martinez Law Center are located?
You're right. Local ordinances can add an extra layer of protection on top of all that.
Okay.
And it's really crucial for attorneys who practice in California to be aware of all these local nuances.
So can you give us some examples of those local ordinances and how they might impact your clients?
Sure. So many cities in Southern California, including Los Angeles, Santa Ana, and San Diego have rent control ordinances that actually place limits on how much landlords can increase rent each year. And a lot of times these limits are stricter than the statewide rent caps. So it's super important to know the specific rules for each city.
So something that might be a legal rent increase in one city could be a violation in a different city.
Exactly. And these local ordinances aren't just limited to rent control. Some cities have additional protections related to things like just cause evictions, relocation assistance, and even tenant harassment.
So it sounds like it's a constantly evolving landscape for tenant rights in California.
It is.
So how do you even stay up to date on all these changes?
It's a lot to keep track of. But there are some really good resources out there to help both attorneys and tenants.
Okay, that's good.
So organizations like the California Apartment Association and Tenants, together they publish regular updates on all the changes in state and local laws.
So it sounds like continuous learning is really essential.
It is.
It seems like, understanding these rights and protections, it isn't just about knowing the law.
Right.
It's about empowering tenants to actually advocate for themselves.
Absolutely. And that's where the work you do at the Martinez Law Center is just so vital.
Yeah.
I mean, by providing legal guidance and representation, you're helping tenants navigate all these really complex issues.
Absolutely.
And making sure that their rights are protected.
Well said. We've explored a really wide range of tenant rights here.
We have.
But there's one final and really crucial point I want to touch on before we wrap up this deep dive.
Okay, I'm listening.
So we've talked about documentation a lot throughout this episode.
We have.
But I want to really underscore just how important it is.
Right.
Especially in those cases where there's no written lease.
You are absolutely right to emphasize that documentation is like the foundation of a strong case for any tenant.
Right.
Especially those who are relying on verbal agreements.
Right.
Or navigating the complexities of local ordinances.
So can you talk a bit more about that? What are the specific types of documentation that tenants should really be focusing on?
Yeah. So first and foremost, any and all communication with the landlord.
Okay.
Whether it's text messages, emails, or even just handwritten notes. All needs to be saved and organized.
So we're creating a paper trail.
Exactly. And if there's ever any kind of dispute, having those records can be crucial to proving the tenant side of things. It really helps paint that clear picture of the landlord-tenant relationship. And it can help establish a timeline of all the events.
So what other types of documentation are really important?
Tenants should also keep very detailed records of all their rent payments,
Right.
including the date, the amount, and how they made that payment. And this is super important if they're paying in cash or through any kind of unconventional method.
So it's not enough to just assume that the landlord's keeping track of all that.
Unfortunately not. It's always best for tenants to have their own records as backup.
Okay, good advice. And speaking of backups, photos and videos are also incredibly valuable
Absolutely.
when it comes to documenting the condition of the unit.
Tenants should take photos and videos of any existing damage before they even move in.
Okay.
And then again when they move out.
Gotcha.
This can help protect them from those unfair deductions from their security deposit.
Right.
And it can also be really strong evidence in any habitability disputes.
So it sounds like documentation is really a continuous process.
It is.
It's not just something you do at the very beginning or the very end of a tenancy.
Right. It's about being proactive and creating that really thorough record that can be used to support their rights as a tenant.
And I imagine this is where your legal expertise comes in.
Right.
You can guide your clients at the Martinez Law Center on the best practices for documentation.
Absolutely. We can help them understand what they need to document, how to organize everything,
Okay.
and then how to use that information to protect their rights effectively.
Well, we've covered a lot of ground in this deep dive.
We really have.
From just cause evictions, habitability standards, to security deposits and documentation. We've explored a huge range of rights and protections that tenants have in California.
Yes, we have.
Even without a written lease.
It's impressive how much protection California law offers.
It really is. It's clear that California law is on the side of the tenant.
It seems that way.
But it's so important to really understand the details of these laws and how to actually apply them in real-life situations.
Absolutely. Knowledge is power. And the more that tenants know about their rights, the better prepared they'll be to secure that safe, fair, and stable housing.
I love that. And before we wrap up, I just want to remind everyone about all the valuable resources available at martinezlawcenter.com.
Great resource.
For anyone who's facing eviction, dealing with those habitability issues, or just seeking legal guidance on their tenant rights, the team at the Martinez Law Center is ready to help.
They are. They're a fantastic resource.
And remember, understanding your rights is only the first step. It's about taking action, seeking that legal counsel when it's needed,
right,
and standing up for what you deserve as a tenant.
Couldn't agree more.
So we've covered a lot of ground in this deep dive, really digging into those rights that tenants have in California, even without a written lease. And it's really reassuring to know that the law here provides some pretty strong protections.
Yeah. It's been a fascinating look, hasn't it? And I think, we've really uncovered some key insights that you can apply to your work at the Martinez Law Center.
Absolutely. We've talked about just cause evictions, habitability standards, those regulations around security deposits, the importance of documentation, and even how those local ordinances can impact things. But before we wrap up, I want to circle back to something we talked about a little earlier, and that's the concept of quiet enjoyment.
Okay.
On the surface, it seems like a pretty simple idea, but I'm guessing there's more to it than meets the eye.
You're right. Quiet enjoyment is more than just about noise levels. It really gets at this fundamental right that tenants have to privacy, to peacefully possessing their rental unit, and to being free from any unreasonable interference from the landlord.
So it's about making sure that tenants really feel secure and have that sense of autonomy in their own homes.
Exactly. And this right is especially important for those tenants who don't have a written lease because it helps to establish those clear boundaries and expectations, even when those terms aren't specifically spelled out, in a formal contract.
So can you give us some specific examples of how this right might play out, in real-world situations?
Sure. So let's say a landlord is constantly entering a tenant's unit without giving them proper notice or for reasons that aren't really emergencies. This could be considered a violation of the tenant's right to quiet enjoyment, even if there's no written lease that specifically prohibits those actions.
So even if it seems like a minor intrusion, those things can really add up to a breach of this.
Right? Absolutely. And it's not just about physically entering the unit either. Landlords also can't harass tenants, make unreasonable demands, or create conditions that make the unit basically unlivable. All of these actions can infringe on a tenant's right to quiet enjoyment.
So it seems like this right really provides a broad umbrella of protection for tenants.
It does, and it's so important for tenants to know that they have legal options if their right to quiet enjoyment is violated. They can file a complaint with their local housing authorities or even pursue legal action to enforce their rights.
So it's not just about being aware of the law, it's about knowing that they have the power to act on it.
Exactly, and that's where the work you do at the Martinez Law Center is so critical. You're giving those tenants the knowledge, the resources, and the legal representation they need to stand up for themselves and really secure, safe, and stable housing.
Well said. And for all of our listeners out there who are legal professionals, remember that your expertise can really make a world of difference for tenants who are facing these kinds of challenges. By understanding those nuances of quiet enjoyment and all those other tenant rights, you can help make sure that everyone has access to housing that is not only safe and affordable, but also respects that fundamental right to peace and privacy.
I couldn't agree more. It's been great diving deep into this topic with you today, and I hope our conversation has given everyone some valuable insights and maybe even sparked some new ideas about how we can keep working to strengthen tenant protections here in California.
I think it's safe to say that California is a leader when it comes to tenant rights. But there's always more we can do to make sure that the housing landscape is more just and equitable for everyone.
Absolutely. Let's keep pushing for progress, advocating for stronger laws, and making sure that tenants know their rights and have the power to exercise them.
That's a wrap on this episode of The Deep Dive. We hope you've enjoyed our exploration of tenant rights in California. And remember, if you're facing any kind of housing challenges or just need some legal guidance, don't hesitate to visit martinezlawcenter.com for expert advice and support.
Great resource. Until next time, stay curious, keep learning, and keep fighting for fair and equitable housing for everyone.
That's it for us today. Thanks for tuning in to The Deep Dive.
Call now 714-442-9741. Thank you.